Have you ever been slapped with a copyright suit? A suit for infringement of copyright in a literary, dramatic, musical, or artistic work. It could be for violating copyright in a software, in a song, a film, or a photograph. If you are ever slapped with such a lawsuit, then you should know about the defenses that your lawyer can take up for you. Now, one of the main things that a court would look into in cases of copyright violation is the intent of the infringer. The court will see whether the infringer deliberately violated the copyright of the work or was it simply an error. Say, for example, you download a pirated version of a software. One of the defenses that your lawyer could plead is that you downloaded it by mistake or without any knowledge that it was pirated. Now, secondly, the lawyer could argue that you did not make any commercial usage of the infringing work. So, for example, if it's an infringing copy of a book or a pirated version of a film, your lawyer could say that you did not make any copies of the book or the film for the purpose of resale, or that you did not make any profit or commercial gain. Then you can say that the infringing copy was basically just for personal usage, right? And thirdly, if you are the defendant and you're able to show that on the date of the infringement or violation, you were not aware and had no reasonable ground to believe that there was any copyright in the work, then the plaintiff can at most get an injunction or a restraining order and a decree for the whole or part of the profit that you made from the sale of the infringing copies of the work. Let me put this in simple words for you. What this means is that on the date of the alleged copyright violation, you did not know that there was even any copyright in that work, and neither did you have any logical reason to believe that there would have been a copyright in that work. And if you can show this, then all the plaintiff can get is an injunction or restraining order to prevent you from further violating that IP or that copyright, and they can basically get a decree for whole or part of the profits that you made, but they cannot get any order of large damages against you. You know, damages means like a penalty imposing that you have to pay large amounts of money to the plaintiff for the alleged violation of copyright. But if able to show these factors which I just told you about in factor number three, then you can basically avoid having to pay any damages. And lastly, always remember that wherever there is a threat of invocation of criminal remedies by the plaintiff against you, then the plaintiff or that copyright holder will have to show that there was a deliberate intent on your part to violate copyright and to also cause damage or loss to him. Right? So, this is a general principle of criminal law that applies to all quasi criminal remedies available under different commercial laws, including IP or copyright laws, right? The element of intent, basically, very central and basic principle of criminal law. So that's it for today. I've told you about some general defenses that are available against civil or criminal allegations of copyright infringement. And I've shared these based on my own experiences representing defendants accused of copyright violation and also from representing plaintiffs that have faced violation of copyright in their works. So I hope that you found today's episode interesting and stay tuned for more exciting episodes on intellectual property and technology laws. Thank you.